Hey there, Andy Nelson. So, something I found in my old Foot Locker that I've been stuffing with things since I was in high school, but haven't opened in quite a while. This pair of socks, this is not a current pair of socks. I bought this in 1990 of all things. And what this illustrates is not just the pair of socks, but what I want to do is show you something that is protected in two different ways. Some people think something's protected by trademark, something's protected by patent, copyright. Some things can be protected by trademark and copyright at the same time, but it's not everything. A lot of people will say, oh, I thought of this great new phrase or slogan, or I got this cool word. I want to protect it by copyright. It can't do that. Copyright doesn't protect short things like that. Copyright protects expressive content. So a lengthier literary work, not just a couple of words, something lengthier, or graphic art, fine art, that sort of thing, it protects. Trademark protects things that point to a source, right? It symbolizes a brand. So it may be a word, a combination of words. It could be logos, slogans, color combinations, things that you look at and you go, you make the mental association to a brand. Apple, or the Apple logo. Ooh, you think consumer electronics, that company that's behind it. All right, Just Do It, or the swoosh, or Nike, that connects you immediately to that brand behind it. That's source identifying is what that does. Bart Simpson right here does both, right? When you look at that, it's a symbol of the brand behind it. The Simpsons, the whole property that's behind that franchise, if you will. At the same time, Bart Simpson, that's graphic art, right? That is graphic art. That's an expressive work that's protected by copyright separately. So what I would say is this. Expressive works like this can be, or typically would be protected by copyright first. As soon as they're created, they have copyright protection. But if they go on to have a brand symbolizing function, that is, they point to a source of goods or services, then they're also going to have a trademark function as well. So they could have protection as two different types of intellectual property. Not everything does that. A lot of logos and things like that are just created. A lot of logos are just, or I should say, graphic art is just created and has no other function other than to basically be an awesome expressive work. It doesn't have a brand identifying function. So copyright is the way to go. Copyright is what protects it. But graphic items, typically logos, but it could be characters like this. I mean, this is not your typical kind of, you wouldn't think of this as a logo, but it is something that definitely points to source. And guess what? The manufacturer of the sock thought so. They actually printed it on here, right here. The Simpsons, TM and copyright, 1990. They even tell us that's the copyright date for this. This doesn't even say the Simpsons on it. So when I say the Simpsons, I'm not saying the Simpsons trademark, because it's not even on here. It's Bart Simpson. Now, Bart Simpson is one of many trademarks for the Simpson franchise, or Simpsons kind of franchise. At any rate, I hope that clears some things up about the copyright trademark crossover, if you will. It's typically going to occur, if at all, when it comes to graphic art, and graphic art that functions as a logo or some other symbol, a brand symbol that immediately points to you, the consumer. You make an association with the brand behind that work of that graphic art. So if you have any questions about this video, drop me a note, shoot me a message, and if someone would benefit from this, please feel free to share the video. So until next time, have a good one. Bye-bye.